Hi everyone, Wayne Unger back for the next episode of our Election 2020 series. Lots going on in the news, but today's conversation is going to focus on abortion and Roe v. Wade. I'm just going to talk through some of the nuances of the case as well as what the Supreme Court actually said. So, politicians and the public boil it down to kind of a pro-life versus pro-choice argument. And they say that Roe v. Wade allows abortions. Well, it's a little bit more complex than that. And today I'm going to dive a little bit deeper. So Roe v. Wade is based in the 14th Amendment, where there are two primary clauses of the 14th Amendment. Number one is the Due Process Clause, and number two is the Equal Protection Clause. Both of these clauses have been used in countless civil rights cases that the Supreme Court has decided, from the right to contraceptives to the right to interracial marriage to, in this particular case, the right to an abortion. Now, Roe v. Wade specifically balances a constitutional right to privacy for the woman against the fetus's right to life and liberty. Now, the court introduced the concept of a constitutional right of privacy, even though that the Constitution, by the way, never explicitly says that anybody has a right to privacy. The court introduced that in earlier cases. For example, in Meyer v. Nebraska, it was about parental control over child rearing. Same thing with Pierce v. Society of Sisters. Both of those cases dealt with a parent's right to bring their child into the world as they see fit. Another case, Griswold v. Connecticut, dealt with the right to contraceptives, that in a nutshell, the government can't reach into certain private aspects of one's life. That is essentially government overreach. Now, to look at what the Supreme Court decided in an earlier case, prior to Roe v. Wade, the Supreme Court said in Meyer v. Nebraska that without doubt, the Due Process Clause of the 14th Amendment denotes not merely the freedom from bodily restraint, but also the right to an individual to contract, to engage in any common occupations of life, to acquire useful knowledge, to marry, to establish a home, to bring up children, to worship God according to one's own conscience, and generally to enjoy the privileges long recognized at common law as essential to the orderly pursuit of happiness by free persons. So in a nutshell, the 14th Amendment protects us from the government infringing on certain private aspects of our life. And that is Roe v. Wade. So the court here balances the woman's right to privacy related to her own body against the fetus's right to life and liberty, and the state's interest in protecting that the fetus's right. So the court ruled that the Constitution guarantees a right to privacy that generally protects a woman's decision whether or not to have an abortion. And it delineates in a trimester kind of framework. And so it says during the first trimester, governments cannot prohibit abortions. During the second trimester, governments could require reasonable health regulations. And during the third trimesters, generally speaking, abortions could be prohibited in their entirety so long as the laws contain exceptions for cases where an abortion is necessary in order to protect the life and the health of the mother. Now, all of this deals with the viability of the fetus outside the womb, basically saying that during the first trimester, the fetus isn't viable outside the womb, and so therefore an abortion is permissible. But during the third trimester, the fetus is theoretically viable outside of the womb, so long as it doesn't hurt the mother's life or health. And for that reason, because the fetus now has viability, abortions are generally impermissible. So we have to look at both sides of the argument, and they are, first, does the fetus have a right to life, liberty, and property under the Due Process Clause of the 14th Amendment? And then second, does the woman, the mother, have a right to life, liberty, and property? And to what extent, if any, can the government infringe on a woman's right to liberty? So I often frame this in a man's perspective as well. Are there any laws on the books that prohibit a man from making a bodily choice? I can't think of one, and certainly a lot of politicians can't think of one, but here's an example of the same logic. So maybe if we pass a law that says when a man turns 40 or 45 or 50 years old, he has to have a vasectomy. That is essentially the same thing. That would be the government, if we pass that law, that would be the government saying, hey, we're going to control a certain part of your private anatomy because we have a state's interest in protecting reproductive systems within our country. That would be clearly a constitutional overreach. The government can't make those decisions for us. And so that is kind of like the equivalent of applying the same logic from Roe v. Wade to a law that would impact men. Of course, that law doesn't exist on the books. So that's the summary of Roe v. Wade. It is not as simple as simply, do we allow abortion or not? There's complex constitutional arguments that are made on both sides. And so that's the nutshell. Ladies and gentlemen, if you have any questions, let me know. Until next time, I'll see you later.